Okay, Mr. Middleton, are you able to hear me okay?
I am. Good afternoon, Your Honor.
All right, good afternoon. So we have all these scheduled for 1:30, but I'm going to just bring people in individually.
Sure.
And I'm going to start with the ones that have legal counsel.
Okay.
So I can't guarantee that the order we're going to do this is the order that they're on the docket. So hopefully, hopefully we can manage it.
Yeah, that's fine. I think I can keep up, hopefully. Got my spreadsheet here, so
Okay. And my intention generally, I think, is to try and call the ones that it doesn't look like there's any kind of issue first. So,
yes. And Your Honor, I did attempt to submit some proposed orders. I don't know if they made it to you or not. I conferred with counsel on the ones that had counsel, and I believe we're in order there. I had to make a guess with respect to the pro se claimants, but we can clarify that it's as it should be before the court enters an order.
okay, perfect. Okay, so the first one I have is the state of Florian Funky, and Mr. Asker is the counsel on that. So, okay, Mr. Asker, if you can unmute, please. Thank you.
Good afternoon, Your Honor. Paul Asker on behalf of the claimant.
Hi, good afternoon. Okay, so we'll go on the record, and this is the matter of the state of Florian A. Funky. The claimant is Charlotte Asker. This is file number 191117712. Mr. Asker is appearing on behalf of the claimant. We have Mr. Middleton here on behalf of the county. And I did have a chance, Mr. Asker, to review the motion to claim the proceeds. I had a chance, Mr. Middleton, to review your response. It looks to me like everything is in order, and that the claimant is entitled to the proceeds. Mr. Middleton, is that the treasurer's position?
Yes, Your Honor. Certainly the claimant's motion was in conformance with the statute. They presented proof sufficient to demonstrate the estate is interest in the property and the personal representative's authority to proceed on behalf of the estate, so long as the court is satisfied that those proofs are sufficient to carry the claimant's burden, then the treasurer would have no objection to the disbursement of funds as prayed. Mr. Asker and I had a chance to speak prior to today's hearing, and I believe agree as to an order regarding form, though I'll allow certainly Mr. Asker to speak on his own behalf with respect to that matter.
Okay,
Yes, I
Mr.
mean,
Asker.
yeah, to the extent you submitted the last form, the last order we discussed, I'm certainly in agreement with that.
Okay. All right. So again, pursuant to statute, the court's role here is to, number one, determine to the extent that there are competing claims, the priority of any claims, the value of such claim. And in this case, there are no competing claims, so the claimant is entitled to the full amount of any proceeds. I did review, again, the motion and the response, and the order is in conformance with the amounts listed. So the court will enter that order with today's date. And Mr. Asker, is there anything else that we need to address for your side today?
Well, we're supposed to submit the W-9. I'll just ask brother counsel. I'm going to mail that form to you rather than email it to you, so that Social Security numbers or EINs are not subject to electronic review by others. Is that sufficient?
Yes, that's certainly fine.
Okay. All right, great. Thank you, Mr. Asker. You're free to disconnect at this time.
Thanks so much. Have a nice day.
Thank you. Oh, Mr. Asker, can I ask you one question before you disconnect?
Yes.
Were you anticipating Charlotte being present? I have a couple people that have signed in on my Zoom that don't have a name. I don't know if you were anticipating her being present or not.
I was not anticipating being present. No. Thank you for asking.
Okay. Okay, great. Thank you. You're free to disconnect.
Thank you.
Okay, I have somebody on the phone with the last four digits, 9011. Can you unmute and tell me your name, please? Okay, and then ma'am on the iPhone, can you tell me your name, please?
Walker.
It's Walker. Okay, and which claim are you calling in on? The individual?
See here. I have the file number. Is
Would
that
it be Mary Waznjak Walker? Is that your matter, ma'am? Yes, Your Honor. That's a pro se claim. It's from the 2015 tax year case.
Okay, Ms. Walker, I'm just going to put you in the waiting room for just a minute, and we'll call your case when you're ready for yours. Okay. That was one that just said iPhone, so I was trying to figure out who that was. Okay. Ms. Mott, can you unmute, please? Thank you. And oops, I'm sorry. There we go.
Good afternoon. My client, I'm sick today, so my client is in my office, and so
Okay.
they should be on the Zoom as well.
Okay. I don't see anybody signed in. It's Miss Kesterloot, is that correct?
Yes, it might be under one of the other partners. Do you think Slough or Deuceman Coy or Holly Blunt?
Oh, Holly Blunt. Okay, there we go.
There's my assistant. Thank you.
Gotcha. I didn't recognize that name. Okay.
Fair enough. Thank you.
Okay, so your client is connected now, Ms. Mott. And this is file number 1214516. And so I had a chance to review the motion. Mr. Middleton, it looks like the treasurer's position, maybe based on your response, is that there needs to be additional or more sufficient proof of Ms. Kesterloot's interest. Is that kind of where you come out on this one?
Yes, Your Honor. We certainly don't categorically object. The records at the time of foreclosure indicated that the property was vested in Theodosia Kefir. Ms. Kesterloot provided, I believe, a death certificate indicating that that individual had passed away, and I believe she was listed as his niece as the informant on that particular death certificate. However, the claimant doesn't offer any explanation as to how she may have succeeded to the interest of Theodosia Kefir, whether through intestacy or devise or otherwise, Your Honor.
Okay, Ms. Mott, can you address that for me?
I acknowledge that's accurate in the pleadings. I wasn't sure if you wanted to take testimony of Miss Kesselut. She's the only living heir of Theodosia Kefir. She's available if you want to take testimony or if you want us to submit an affidavit. I'm happy to do whatever proofs are necessary.
Yeah, so, oh, go ahead, Mr. Middleton.
Sorry, Your Honor, I certainly won't supplant the court's role in determining the sufficiency of evidence. I suppose I would say pursuant to MCL 700.3901, testimony, I believe, would be appropriate to establish the factors outlined in that particular statute for parties interested in estate property to claim in the absence of administration, assuming that there wasn't a probate estate that was ever opened with respect to this property. But of course, would defer to the court as to what proofs you feel are most appropriate or sufficient.
Yeah, so I guess my concern with just testimony, Ms. Mott, I mean, it certainly could, and Mr. Middleton's correct in terms of the statutory language. I think it could establish those things. I think what I would need is some kind of documentary evidence that there was never, a will or anything was ever probated. I mean, I can acknowledge for the record today, it doesn't appear that anybody has come forward to challenge Ms. Kesselut's claim. And I think you could submit whatever she would need to testify to by way of affidavit in addition to that. I agree with Mr. Middleton that I don't think, there's nothing that I see that would preclude Ms. Kesselut's claim here. But I do think based on the statutory requirements, I would need more than what we have to establish that she is a proper claimant under the statute. So, and the case law is pretty clear that the burden is on the claimant to come forward with sufficient evidence. So I would be happy to set this on for another hearing, as quickly as you can get that to the court, Ms. Mott, and the court is certainly not denying the claim here today.
Okay, that sounds great. We can do that.
Okay. All right. Thank you. You are free to disconnect along with Ms. Blunt there.
Thank you.
Okay. Let's see. Counsel Breckenridge, can you, you're going to need to connect your audio there. Whoever's signing in under Alex Breckenridge, you're going to need to connect your microphone, your audio. All right, not sure what's happening there, so I'm going to move on from that one. Do you know what case that is, Mr. Middleton? You're muted now.
Sorry, Your Honor. That's 15-15904 CZ.
Okay, Holly Hoffman. Okay, counsel, can you unmute and put your appearance on now that you're connected? There we go.
Yes, Alex Breckenridge, P86394, on behalf of the claimant, Your Honor.
Okay, great. Thank you. And Mr. Middleton's identified the case number on that. So that is one. Mr. Middleton, I'm going to kind of put this one out to you first. That is one that I for whatever reason, I didn't get a judge's copy or a copy of the claimant's motion on that. So that wasn't one I was able to review prior to the hearing today to determine whether there were any issues or not on that one. So Mr. Middleton, can you tell me the treasurer's position as to that one?
To clarify, Your Honor, you didn't receive our response or you didn't receive the motion itself?
I did receive your response. I just didn't receive the motion from the claimant.
Your Honor, essentially there aren't any issues. The claimant's motion conforms with the requirements of MCL 211.78T. It was clear based on the record of the Register of Deeds that Holly Hoffman did own the subject property prior to foreclosure. There were no other interest holders identified by the treasurer, and none have appeared. The only minor issue, the claimant did indicate that they did not purchase the property under MCL 211.78M. In other words, they did not purchase the property from the tax foreclosure sale. That statement was inaccurate, though admittedly this is a common stumbling point for claimants all across the state. So I certainly do not think that there was any, intentional obfuscation, Your Honor. It's simply a confusing point of law. There are certain statutory requirements that are triggered when a claimant did purchase the property pursuant to 78M, that certain payments be made to anything owing to a tenant at the time of foreclosure, or certain civil fines that may be outstanding. The treasurer is not aware of any such costs that may be owed, simply pointed out the fact to clarify the record, but don't believe any specific actions required by the court. So beyond that, Your Honor, the treasurer would not object to payment of the proceeds as sought by the claimant. And Sister Counsel and I did have an opportunity to confer regarding a appropriate form of the order prior to today's hearing. So with that, Your Honor, the treasurer would have no further objection, and certainly would welcome any other input from Sister Counsel.
Okay, Ms. Brackenridge, anything that you needed to add to that?
No, Your Honor, I agree. Mr. Middleton and I had a nice conversation. I think everyone is on the same page, and we are thankful that we're able to get this off your docket.
Okay, all right, thank you. So I did have a chance to review the order, and so I'm signing that order with today's date. Ms. Brackenridge, anything else we need to address on your claimant's file?
No, Your Honor.
Okay, Mr. Middleton, anything further on this one?
No, Your Honor, I think our response speaks for itself, as well as the terms of the proposed order.
Okay, thank you. Ms. Hoffman and Ms. Brackenridge are both free to disconnect at this time.
Thank you, Judge.
Okay, Mr. Goodnow, if you can unmute, please. And you're signing in on behalf of the claimants for the estate of Ronald Chu, is that correct?
Yes, Your Honor.
Okay, those are file numbers 1917712 and 1817291.
Yes, Your Honor.
Mr. Middleton, can you make a record with regard to the county's position as to these?
Yes, Your Honor. Just a brief moment to pull up my file. Your Honor, starting with the first case, that being 18-17291CZ, concerns 3 parcels of real property located in Otsego County. Each parcel was clearly owned by Ronald Chu, by virtue of a warranty deed. It's recorded in 1395, page 310 of the Otsego County Register of Deeds. Claimants made the requisite notice filing. They filed a timely motion. They also presented evidence demonstrating that the individual was appointed as the administratrix of Ronald Chu's estate. So the treasurer has not identified any other party who may have an interest in the property, and none has appeared. So the treasurer would not object to the disbursement of funds with respect to the 3 parcels at issue in the 2018 case. And Mr. Goodnow and I also conferred, and I believe have presented an agreeable order to the court memorializing or awarding the relief sought.
Okay, thank you. And were you just addressing the 18 case? Did you want to address the 19 one as well?
Sure. With respect to the 2019 case, this concerns 2 parcels of real property. Also, obviously in Otsego County, Ronald Chu was the only individual with an interest in the real property at the time of foreclosure, owned the parcel by warranty deed. The claimant again made the requisite notice filings and filed timely motions that comport with the statutory requirements. They've also demonstrated that the administratrix was duly appointed on behalf of the estate. And so with respect to these parcels, the treasurer would have no objection to disbursement of the funds as prayed, Your Honor.
Mr. Goodnow, as to either of those files, any record that you needed to make?
No, Your Honor, I think that that covers it. Yeah, we discussed the orders this morning, and we're in agreement with those, so.
Okay. So I've had a chance to review the orders as well as the petition and the response from the treasurer. The court finds that the claimant is proper party with legal interest in the proceeds, that no one else has come forward to challenge that. And the values are correct based on the information contained in the pleadings. I've signed both orders with today's date. Mr. Goodnow, anything else from your side that we need to put on the record in this file?
No, I don't believe so, Your Honor. Just as a point of clarification, I know that there's the amounts that need to be withdrawn for the 5% sale recovery fee. I suppose it doesn't matter too much if the proceeds are distributed out and the administratrix writes a check back to the county for that amount, or if it just comes out of the check that gets sent to her as administratrix. I don't know if there's a preferred way for that to happen on your end either, Lucas, but.
Yeah, I should clarify. You'll receive the net amount, and the remaining proceeds definition already includes the deduction of that fee. So that bottom line number that the court is awarding is the amount your client will receive, and there's no further accounting that you'll need to make for any other costs or anything of that sort.
Okay. All right, sounds good. And yeah, we'll get a W-9 sent over. And yeah, that sounds great.
Thank you.
Okay. All right. Thank you, Mr. Goodnow. You're free to disconnect. Mr. Goodnow,
Thank you
one
very much,
question. I should have done this before. Did you have anybody, your client, appearing today?
I believe that Miss Allen is the 1479 number that's in this call with us. She was in the waiting room as well, I know. So I believe that is her.
Okay, so she has been in and been able to hear this.
I believe so, yes.
Okay, she didn't unmute or identify herself, so I wasn't sure who that was, but all right, great. Thank you. You're free to disconnect at this time.
Yeah, thank you very much, Your Honor. Thank you, Lucas.
Thank you.
Mr. Middleton, I'm bringing the Childers in as the next one.
All right.
Okay. Folks, are you Michael and Janet Childers?
Yes, sir.
Okay. All right. So this is file number 1616403. The record should reflect that the claimants are present here today, along with Mr. Middleton on behalf of the county. I did have an opportunity today, prior to today's hearing, to review the petition and the supporting documents that were attached as exhibits. I also had a chance to review your response, Mr. Middleton. It does appear that all the requirements have been met. I know that there was some issue with parcel 5, which the claimants were land contract vendors on. However, in my view, they still have legal title to that. There hasn't, according to your brief, there hasn't been any kind of showing that they didn't retain legal title even in light of the land contract. So I do believe that they would be entitled to the proceeds. But I'll let you address that if there's a different position. Mr. Middleton.
Thank you, Your Honor. I believe you captured it adequately and correctly. I would just clarify that was with respect to parcel 4, what we have denominated as parcel 4. That's 071-027-100-035-05. Gregory and Adele Amejka were purchasing the property on land contract, at least according to the records of the Register of Deeds. However, as Your Honor has noted, they've not appeared seeking any portion of the proceeds, and the deadline for them to do so has now passed. So otherwise, if Your Honor is satisfied with the proofs presented, Treasurer has presented a proposed order. I would simply ask for clarification from the claimants before the court enters it, that I've adequately spelled out the payment terms, and Mr. and Mrs. Childers, I have spelled out that the funds should be paid to Michael J. Childers and Janet L. Childers and directed to you at 1230 County Road 3411, Clarksville, Arkansas 72830. Is that correct?
Yes, sir.
And so, Your Honor, that is the treasurer's position. If claimants have any other clarifications they wish to make, certainly those would be appropriate as well.
Okay, Mr. and Ms. Childers, I'm going to sign an order dispersing those proceeds to you as provided in the petition. Did you have any questions at all today?
Will the fees that we are required to pay be taken out of that before we receive it?
Yes, they
Mr.
will.
Middleton.
Those fees are already baked into the remaining proceeds figure that were on the notices you received. The
Yes, sir.
total amount which would be paid to you under this order is $4,561.22 with no other expenses or costs that you would need to account for beyond that.
Thank you.
Okay. All right. So the court has entered that order, and Mr. and Ms. Childers, you're free to disconnect.
Thank you.
Thank you.
And I would note for the Childers, the order provides that within 21 days of today, the treasurer will send you a check to the address that we indicated. I believe I sent you copies of IRS Form W-9. The order also requires that you provide that to the treasurer. If you didn't get those, you can give me a call and we can talk about it. But the order requires that you submit that form to the treasurer. It's just a tax form.
Okay. Thank you.
Okay. Thank you. And you are both free to disconnect at this time. Okay, Mr. Parks, if you could unmute, please.
Can you hear me now?
I can, yes. Sir, are you Larry Parks?
Yes, I am.
Okay, we're on the record now. This is file number 1214516. This is a petition from Mr. Parks. I did have a chance to review the claimant's motion. I did have a chance to review your response as well, Mr. Middleton. And it does appear that Mr. Parks is a proper claimant in terms of his interest in the property, and that he would be entitled to the full share of the proceeds. Mr. Middleton, is that correct from your standpoint as well?
Your Honor, that is correct, assuming that those are your findings based on the evidence that was presented. I believe Mr. Parks presented a detailed recitation of what happened with respect to the chain of title. The only moderate complication is simply that there was a pending, I believe he and his ex-wife were purchasing the property on a land contract. Subsequent, subject to a divorce, she deeded her interest in the property to him, and then later a deed in satisfaction of the land contract was issued with her name on it as well. His explanation certainly is plausible with respect to how land contracts operate. So if the court again is satisfied that Teresa Parks has no further interest, then the court's determination certainly would appear appropriate, and the treasurer would have no further objection. There was also an outstanding mortgage, but Mr. Parks presented evidence that it was fully paid and discharged. And beyond that, the mortgagee did not appear to seek proceeds. So again, with the court's findings, the treasurer would have nothing further to add.
Thank you. So having reviewed all the documents that were submitted by Mr. Parks with his claim and motion, I do believe that the facts as stated by Mr. Middleton are supported by appropriate evidence, and that Ms. Parks does not have, Teresa does not have further interest in the property, and that, or the proceeds rather, and that the mortgage was properly discharged. So the court finds that Mr. Parks has met his burden, that he has priority in terms of the claim, and that the amounts as provided in the order are correct based on the records of the county. So Mr. Parks, I'm going to sign an order here today for disbursement of those funds to you. And do you have any questions at all?
No, I don't. Thank you.
Your Honor,
Mr. Middleton. Yep.
Before you enter the order, can I just confirm that it's going to be directed to where Mr. Parks wants to receive it? Your Honor and Mr. Parks, the order currently provides that the check will be made payable to Larry D. Parks, and that it will be mailed to Mr. Parks at 6633 Summit City Road, Kingsley, Michigan, 49649. Mr. Parks, is that correct?
That is correct.
Thank you, Your Honor. Then I believe the order is appropriate as presented.
Okay. All right. Thank you. I've signed that order. And Mr. Parks, if you don't have any further questions, you're free to disconnect this time.
Okay. Thank you, Your Honor.
Thank you. Okay. Okay, we have Ms. Walker back reconnected now. So this is file number 1716883. Ms. Waznjak Walker is present today, as is Mr. Middleton. I did have a chance to review your motion, Ms. Walker, as the claimant in this case, and your response, Mr. Middleton. The only issue I can really see, I think there's no question that Ms. Walker is a proper claimant. The issue I see is, however, that under statute and as interpreted by case law, the claimant is only entitled to reimbursement of proceeds up to their interest in the property. And the records, and correct me if I'm wrong, Mr. Middleton, but the records that I reviewed that were submitted indicate that Ms. Walker has a 1/9 interest. Is that correct?
Yes, Your Honor, that was the interest reflected on the executors or personal representatives deed recorded in Liber 1402, page 373.
Okay, so Ms. Walker, what that means for you is there isn't much left over. The proceeds were $944, so you'd be entitled to 1/9 of that. After the fees and interests, it comes out to a very small amount. So, you know, we have two choices. The records that I've reviewed indicate to me that you have a 1/9 interest. If you believe that you have a greater than a 1/9 interest, we can adjourn this today. And if you can provide documentation to the court that you know you have something greater than that 1/9 interest, I certainly would consider that. Otherwise, the court can enter an order for your interest here today. So that's kind of up to you. Do you know how you want to proceed, or do you have any questions?
I'm not quite understanding what the 1/9 interest is.
So the records from the Register of Deeds indicates that your ownership interest in this property is a 1/9 interest. So there's 8 other individuals that you share ownership with.
No, I don't. So that's incorrect. They all signed off on it at the time, and I was the sole owner. The deed went solely to me. And I was the only one that ever received any tax papers or anything. Nobody else did. So I don't understand how anyone else could have any interest in it when they all signed off.
Okay, so that's what I'm saying. If you want me to adjourn this hearing today, if you can provide documentation of what
I
you're
don't have documentation. It's been almost 10 years.
Okay. Well, I can't just go on what you're saying. I have to go on paperwork documentation, and the documentation that I have reflects a 1/9 interest. So if you believe that it's different than that, I'm certainly willing to consider that. I just would need.
Yeah, and even on the papers, even on the deed, there was only 4 other people that the original, what they had sent, and then they all signed off on it.
Okay.
Did they? Sorry,
go ahead, Mr. Middle.
Ms. Walker, was there another deed? Because the only deed that we found, it was from 2016, May 6th, 2016.
Well, I would have to get a hold of the attorney that handled all of the inheritance and see, because it was solely left to me because everyone else signed off on it. Nobody had any interest in it at all.
In this particular deed, it lists Marie Lil Davis. She got a 1/3 interest on this deed.
Well, why aren't they bothering anybody else? It doesn't make any sense. I've been the only one that's been contacted.
That I don't know. We would have notified, all these individuals were notified during the underlying foreclosure proceedings because they were identified at that time, as well as you. They haven't appeared to claim any portion of the proceeds. So certainly if you had additional documentation that showed that they conveyed their interest to you, the treasurer certainly would be willing to.
Yeah, I don't have time for all this business back and forth and making court things. It should be that.
By them not coming forward.
Yeah, and then nobody even came forward with anything.
Okay, well, it's up to you. If you want the proceeds, if you can provide the documentation, then I'm more than happy to sign an order for that, but I can't do it based on what we have today. So unless.
Yeah, well, I'm going to adjourn it, and I will contact the inheritance lawyer that represented it for the probate and see if he has documentation to it, because they all signed off on it.
Okay. Okay. So once you contact that person, if you will contact the clerk's office here, we can get it set for another hearing date. Okay.
All right, thank you.
Okay. Thank you. Okay, folks, can you tell me your name, please?
Patrick S. McComus.
And I'm Julie McComus.
Okay. All right. This is case number 1214516. The record should reflect that the claimant, Mr. McComus, is present here today by Zoom. We have Mr. Middleton on behalf of the county. I did review the claimant's motion as well as the county's response. And so Mr. Middleton, it looks like similar to the last case. It looks like Mr. McComus is well, according to my notes, Mr. McComus would be entitled to a 1/4 share of a third. Is that correct?
Yeah. My brother is now deceased, but yes.
His mom was entitled to 1/4 share, and then Ed is then entitled to 1/3 of her share.
Right. Okay. Got it. All right. Mr. Middleton, I mean, that's what I find based on the documents, unless you're seeing something different from your standpoint.
No, Your Honor. I would note, we did the best we could to piece things together. We did identify an obituary for Shirley McComus, which I think presented the facts that we've presented them. Perhaps it may just be appropriate to have Mr. McComus confirm those facts via testimony if the court wishes, and if they're content to receive the 1/3 of 1/4, then I certainly believe that would be appropriate. Although, again, it's Your Honor's determination to make with regard to the sufficiency of proofs.
Yeah. So, Mr. McComus, what I would need to do is, because I know what you wrote in the petition, from a legal standpoint, it's different if I put you under oath and you actually testify to those facts. What we need to do is establish that you would be entitled to succeed to your mother to 1/3 of your mother's 25% share, and why. So, so I'm going to place you under oath. If you raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. Mr. McComus, you're a biological child of Shirley McComus, is that correct?
Yes, sir.
Okay, and Ms. McComus passed away. Having a hard time reading the copy here, but back in 2014, is that correct?
Yes, sir.
Yeah.
Okay. At that time, who were the heirs of Ms. McComus, to your knowledge?
My sister Yvonne Henderson, myself, and my brother Michael.
Okay. And when she passed, did she have a will that disposed of this property in some way?
There was an irrevocable trust, if that's a family trust, that was drawn up, and that was back in 2013, so it would have been before my mother's death.
Okay, and the trust is how this property was, or all of her estate was distributed through the
Correct.
trust? Okay. And what was your interest to receive any of her estate in the trust?
It was 1/3 at that time of her passing.
Okay. Okay. Mr. Middleton, did you have any additional questions?
No, Your Honor. I think either way you slice it, the testimony is sufficient. The property wasn't part of the trust, so I think the operative facts would, or the property was never conveyed to the trust as far as we can tell, but I believe the operative facts would, result in the same outcome, Your Honor.
Okay. All right, I agree. So the court finds that Mr. McComus is a proper claimant under the statute, and that he would be entitled to proceeds up to 1/3 of 25%. And so Mr. McComus, I believe, and I didn't have a chance to look at that order yet. Or Mr. Middleton, were you able to prepare an order on this one? Maybe I haven't seen that one.
I didn't prepare one for this, Your Honor, just because I wasn't certain how the court would ultimately rule, but I'm certainly happy to prepare one and submit it pursuant to the 7-day rule. The amount of the proceeds, 1/3 of 1/4, is 8.33%. It's $218.94.
Okay, thank you. So, Mr. McComus, the court will sign that order once Mr. Middleton presents it. And then, Mr. Middleton, did you need to confirm where that where those proceeds should be sent?
Yes, thank you, Your Honor. Mr. McComus, would it be payable to Patrick S. McComus and mailed to you at 28 4th Street, Plainwell, Michigan, 49080? Is that correct?
Yes, that would be fine.
Thank you. And as the judge indicated, I'll prepare a proposed order and you'll receive a copy of that with a notice indicating some further information about what that means.
Okay.
Okay.
Okay, thank you. Mr. McComus, did you have any questions at all?
No, sir.
Okay, thank you. That's all. And you're both free to disconnect at this time.
All right. Thank you, sir.
Thank you.
Your Honor, I didn't prepare orders for either of the remaining two, so they're sort of in the same camp as the McComuses.
Okay, gotcha. Thank you. Okay, I cannot see you, but whoever's connected, can you tell me your name, please?
Hi, sorry, this is Rachel Allen.
Miss Allen, okay.
Sorry.
That was the Ronald Chu matter, Your Honor.
Yeah.
I believe.
So, yep, Miss Allen, we already, I'm sorry, I didn't, what you were signing in under didn't identify what case you were signing in on. So I didn't bring you in for that hearing, but we have had that hearing and the court did approve dispersal of the proceeds.
Oh, my apologies. This is acting very strange. I had my video and stuff on, but that's apparently something I did incorrectly.
That's okay. Did you have any questions at all?
No, I didn't have any questions. I just kind of wanted to see what the, response was and where we were at.
Yep, your attorney appeared, and again, the court approved dispersal, and so you should be receiving those funds.
Okay, I appreciate it. Thank you.
Okay, thank you. If you have further questions, give your attorney a call and he can fill you in.
I will do that. Thank you.
Thank you. Mr. Middleton, I had one left. That was the motion of Ms. Ortesi. I do not see anybody else in the Zoom waiting room. Obviously, we're well past the time for hearing. So I'm simply going to just pass that motion. If Ms. Ortesi wants to refile that and get a new date, she's free to do that. But otherwise, the court's not going to take any action on that motion. Did you have any record you'd like to make on that one?
No, Your Honor. I believe the court statements are sufficient and our response is sufficient. I do believe that may have been filed late as well. But in any event, the claimant has not appeared.
Okay. All right. That's all I have for today then. Thank you. Thanks for all your responses on those individually. I went through them all individually. This is not a proceeding that I've had yet, so I found your responses to be very helpful in terms of all the statutory requirements. So I appreciate the time and effort that you put into those.
Yeah, thank you, Your Honor. Tried to make it as efficient as possible, and I apologize that I didn't get those orders to you sooner, but I find that, especially with pro se claimants, getting them entered the day of makes it a heck of a lot easier.
And I have to say, I read you at least either authored or co-authored the ICL section on this. Is that right?
Yes, Your Honor.
Yeah, so I read through that. That was helpful as well. So.
Well, and Kevin Smith certainly carried more of the water on that endeavor than I did, but I'm honored to have my name next to his on the ICL book. So.
Okay, that's all I have for today then. Thank you, and you're free to disconnect.